So good morning, everyone, and thank you for joining our Junior Energy In-House Lawyers webinar series. We are thrilled to be kicking off our 2026 series today. My name is Derek Anderson, and I'm a solicitor in the Energy Real Estate team here at Burness Paull. Today, I'll be joined by my colleagues Hazel and Gemma of the Burness Paull Planning team, Ellie of the Grid and Regulatory team, and Tyler and Marianne of the Energy Real Estate team. Before we get started, a little bit of housekeeping. Once you've joined, please ensure that your mute button has been selected to limit the background noise. Please note that today's webinar won't be interactive, so please do reach out to any of today's presenters with follow-up questions, or if you'd like assistance with any of your projects. Our contact details will be available at the end of the slides. Today's webinar will also be recorded, and if you have any queries on that, please do check out our privacy policy, which is available on the Burness Paull website. You will receive the recording over the next few days. So, what are we going to cover in today's session? This morning's webinar will focus on the life extension and repowering of existing renewable energy projects. With many projects now reaching the end of their originally planned for or consented to life cycles, developers are looking at these options as alternatives to completely decommissioning their projects. Whilst today's webinar will primarily focus on the planning and property considerations, we will also address the key grid considerations. The main element of this will be discussing the misunderstanding that a developer will hold its grid capacity in perpetuity. In terms of repowering, we would just note that this webinar has been prepared to focus on where a project is being repowered by the same developer as is operating the original project. This is what we would expect to see in the majority of cases. However, we are of course conscious that there may be instances where this is not the case, and this would bring in an added layer of complexity to progressing your project. Our team would be delighted to discuss any questions on the approach where the repower developer is not the incumbent operator. So the first step for today is to explain the key differences between a life extension and a repower. Let's start with the life extension of a project. This will typically be a more straightforward process than doing a repower project. A life extension involves retaining the existing layout of your project and the assets on site and continuing to utilize them for as long as is economically viable. This may involve replacing components, but it will not involve the installation of new assets. The key considerations for this option are to extend your existing land rights, i.e. all of your leases, and also applying for extensions to your planning consents, as both of these will include long stop dates. You will, of course, also have to review the likes of your O&M agreements, your offtake agreements, and your project funding. Whilst these will not be covered in today's webinar, please do reach out to us on how we can support you with these. From a properties perspective, your first step should be to review the existing leases for any extension provisions and for any exact procedures that you're going to have to follow. It is worth mentioning from the outset that life extensions are not uncommon. The typical operational lifespan for a renewable energy project was around 25 years or so, and this was originally designed to roughly reflect how long the infrastructure and equipment was intended to last for. Over time, the renewable sector as a whole and the technology that it's used within the projects has developed. And the result of this is that equipment, such as the turbines used in a wind development, can now operate for much longer. It often then makes commercial sense for an operator to continue to run with existing infrastructure for as long as they can. And we're increasingly seeing life extensions being the preferred, most efficient structure to deal with this. Moving on to a repower project, we consider this to be a competitive market, both with existing operators of projects and also, as we flagged earlier, operators looking to pick up projects and build on these. A repower project involves completely upgrading your project. You will decommission the existing assets and install new assets at the site. This will allow you to install the latest and most efficient technologies and also potentially increase the capacity at the site. Unlike with a life extension, this will tend to involve completely new commercial negotiations for your land rights, and you will also require a new planning application to be prepared, and also the associated supporting environmental information. You will need to consider how the decommissioning of the existing project can be managed while simultaneously planning for the installation of the repower. It is likely that the planning authorities will require the decommission of the first project to be completed before you can actually commence any work on the repower project. We would also flag from the outset that we see developers adopting a hybrid approach to these options, So this is where they may extend the life of the project, but also install certain, but not a full suite of upgrades. So for example, only replacing the blade components on a wind turbine. Whilst the two options are ultimately different in nature, they do share some similar benefits. So these would include you will already understand the wind data and yield records for the site, and will possess an understanding of the local opinion on the project. You'll be able to utilize existing infrastructure, such as the access roads and substations already in place, and this will ultimately save you costs. You may also be able to reduce the number of turbines or other technologies installed and be able to produce the same results. With both a life extension and a repower, you will also benefit from understanding of the existing positioning in relation to the land. You should, however, also consider whether landowners have now changed, both at the primary site or along any of the access routes, and whether any fresh title work should be carried out to confirm changes in ownerships or new burdens on the land. It may be the case, though, that you will only require a review of the title post the entry date of your original lease, as opposed to a full title report that would typically be required for a new project. I'm now going to pass on to my colleague Ellie, who will outline the grid considerations involved in the life extension and the repowering of projects.
Thanks, Derek. Moving on to consider the regulatory elements in the context of extending the life of a project or repowering. There are three main points to note, focusing on grid, contract for difference, and power purchase considerations. So firstly, there are three scenarios that are relevant to a repower project, and it is important to consider which one applies. Firstly, will the repower project require the same capacity as the existing project? Will the repower project require an increase in capacity? Or will the repower project require any technical or project-specific amendments against the current connected project? Depending on the answer to that question, it will potentially dictate the course of action for a developer's engagement with the network operator. So taking each one in turn, firstly, a repower project with the same capacity. There is perhaps a misconception in some quarters that a connection agreement is enduring and for the benefit of a developer as long as the developer requires it, i.e. the connection charges have been paid for and then it's for the developer to own and operate the connection. Whilst it is true that connection agreements do not have an expiry date and they continue on an enduring basis, it is important to engage with the network operator at an early stage to seek any necessary comfort required that an existing connection agreement will remain relevant for a repower project. It is important to note that a connection agreement will remain relevant for a repower project and for a prolonged period of de-energisation would constitute a termination right under connection documentation. And therefore the time taken to decommission an existing project and build a repower project could potentially see developers fall into an event of default scenario. Therefore, early engagement with the network operator on plans, timescales, and seeking the appropriate comforts is essential before embarking on any repowering project. Next, a repower project with an increased capacity. If a project seeking to repower wants to increase the capacity of the project, then it is important to note that the developer may need to apply for a new connection to do so in order to increase the capacity afforded to the project. This is a very different scenario from what I just mentioned, in that the connection itself is no longer fit for purpose and needs to be upgraded for the new project. This will apply regardless of if the developer already has an existing grid connection. A request for additional capacity will potentially require the developer to rejoin the grid queue and be treated as a new connection application or modification. As such, this is a much more involved process to obtain a new connection. And with Gate 2 processes in place going forward, together with the uncertainty created as the Gate 2 processes bed in, a developer seeking to repower should ensure they are entering into conversations with NESO or the DNO at the earliest opportunity in order to determine the best way to protect a project's interests and its capacity. Thirdly, a repower project requiring a change in the connection design or characteristics. If the developer is intending to repower under the same grid connection agreement and is not seeking additional capacity, then it is important to note that the connection agreement may still require amendments to reflect any changes resulting from the new turbine design or the layout of the connection infrastructure, together with any other technical considerations. On that basis, if keeping the existing connection is what the developer wants, then it should still be discussed with the network operator to retain it. Even though it can maybe seem to be deemed lower risk than requesting additional capacity, there are still important considerations that can impact the project from a technical and practical perspective, and also from a financial perspective in terms of additional costs and complexity in the connection process. Moving on to connections reform, as already mentioned, how the connections reform process will impact any proposed repowering is currently unclear, which can be said about a lot of connections reform to date. We are at the early stages of connections reform, and going forward, it will be interesting to see how repowered projects are treated as capacity is available on the network, strategic plans and clean energy targets are potentially revised, and whether repowered projects are simply in the mix alongside new onshore wind developments, particularly where additional capacity is required, or where the existing capacity is deemed to have defaulted back to the grid. Turning now to Contract for Difference, or CFD scheme, in the context of repowering. So for the first time, revenue support is now available for repowered wind farms. Beginning with the most recent round of CFD support under Allocation Round 7, the UK Government is now providing 15 to 20-year fixed contracts for higher capacity wind turbines. So in order to qualify, there are conditions for eligibility, which at a high level are, firstly, the developer must evidence the original project commenced commercial operation 25 years before the target commissioning date of the repower project, which is effectively to demonstrate that the project has reached the end of its initial operating life. The project must have a generating capacity of greater than 5 megawatts. Major generating components of the old project need to be removed, constituting a substantial replacement of the existing generating assets. And the existing generating asset must not be receiving any other electricity generation subsidy by the time it reaches the end of its operating life, as provided for in the CFD application. The introduction of repowered projects to the scope of the CFD scheme is a positive step to support investment for repowered projects and recognises that there is a need for more cost-effective and smarter development solutions for renewables projects. This will come as a welcome change for developers, ensuring that older sites can still contribute to the UK's net zero targets, with as much value as possible being extracted from existing projects. Finally, moving on to consider how power purchase agreements, or PPAs, need to be considered in the context of repowering. Similar to grid connection agreements, it is important to understand what the requirements are for the repowered project in terms of its size, capacity, and timescales for development. An existing PPA for a project with a licensed supplier or corporate off-taker will have an end date. It's unlikely to be enduring for as long as the project generates electricity, as was the case with the grid connection. However, with an off-taker in place, it may make sense in some cases to seek to keep that off-taker in place for the repowered project and either extend the term of the PPA or seek to make necessary amendments. To do so, a developer would have to engage with the counterparty regarding its plans and consider the provisions of the PPA and how this will be impacted by any repowering process. For example, PPAs will contain obligations to maximise generation, permitted outage events, extension of the project capacity, along with specific provisions for revisiting pricing and commercial balance of the agreement in certain circumstances. To revisit an existing PPA to potentially extend to cover a repowered project, appropriate amendments and concessions would need to be made with the off-taker to allow the development of the repowered project. In practice, this might simply be a new PPA with the off-taker to reflect what is essentially a new project. However, there may be cases where the parties are happy to work together to extend the terms and amend the existing agreement if it works for the parties. Of course, the alternative is that the existing PPA is brought to its natural end and a new off-taker is sought, reflecting that the market at the time may be more beneficial to the generator who can seek a better financial position by negotiating a new PPA. So, to round up, our key takeaways from a grid and regulatory perspective are that, firstly, there is an initial misconception that there are no grid implications in repowering. For example, the grid rights have been paid for, the assets have been constructed for connection, and therefore the developer should have the right to connect on an enduring basis. As explained earlier, this is not the case. Fundamentally, repowering is a revised project with slightly different connection characteristics relating to increased capacity or technical considerations, and requires participating in the connection process for a new connection. Infrastructure that is built 20 plus years ago may not be sufficient anymore, and the connection agreement should reflect that. It is therefore important to discuss with the network operator to understand options and seek assurances if looking to retain an existing connection and believe it could be made to work for a new project. If, however, changes are required, this will need to be cleared with the network operator and potentially treated as a whole new connection. Finally, Repowering has begun to find its place in subsidy regimes, which should be a positive step to repurposing sites, potentially reducing competition for new sites, and alleviating some financial constraints for developers by providing a stable route to market. I will now pass on to my colleagues Hazel and Gemma to cover planning considerations in the context of repowering and life extension.
Thanks, Ellie. My name is Hazel Noble, and I'm joined by my colleague Gemma Hughes. We are solicitors in Burness Paull's Planning and Environment team, and today we will be covering briefly some of the key consenting issues when it comes to repowering life extension of projects. Repowering life extension is becoming something of a hot topic in planning, as a substantial number of Scottish wind farms are nearing the end of their intended operational life. Developers must successfully navigate the planning system to ensure that repowering life extension strategies are viable. So today I'll begin by providing an overview of the various routes to consenting for these types of projects, before passing over to Gemma, who will look at some of the considerations going into determination of these applications, including policy considerations and planning agreements. And given the length of today's webinar, we will focus on developing onshore projects in Scotland, although the team does have wider experience. So beginning then with routes to consenting, how does a developer go about obtaining planning permission or consent for either a repowering or life extension project? Very briefly, let me run through the types of planning permission or consent that a developer may hold for an onshore wind development. In Scotland, there are two main consenting regimes for energy projects. The first of those is for projects 50 megawatts and under. For these, the developer must submit an application to the local planning authority under the Town and Country Planning Scotland Act 97. The second is for projects over 50 megawatts. Consent is required under Section 36 of the Electricity Act 1989, and deemed planning permission under Section 57 of the 1997 Act is also required. This application is submitted to the Energy Consents Unit of the Scottish Government, and the Scottish Ministers are the ultimate decision makers. Each system has its own unique challenges. It is very important to consider early in the consenting process whether your new life extension repowering scheme will push you over the threshold into a different consenting process. If, for example, repowering scheme increases capacity above the 50 megawatts, the local authority consent will need to be replaced by a new Section 36 consent rather than a variation. Today, onshore wind farms of over 50 megawatts are relatively common, so it's likely that increasingly we will see this happening. It's worth noting that the Scottish Government is currently consulting on proposals to increase the 50 megawatt threshold for onshore developments, meaning that an increasing number of applications will be dealt with at the local authority level. This would follow suit with down in England, where for the English equivalent nationally significant infrastructure project regime, the threshold has already been raised from 50 megawatts to 100. So the generational capacity of the project is therefore something to keep in mind. Returning then to repowering life extension, what are your consenting options? So life extension, firstly, as Derek has covered, involves extending the duration of the existing planning consent. Planning permissions for wind farms are typically time limited and expire at the end of a defined period. This period is typically defined in a condition attached to the permission or consent. For life extensions, it may be possible to vary the existing planning permission or consent without the need to apply for a completely new one. The advantage of a variation is that the only matter that is assessed by the decision maker is the impact of the variation, not the principle of the wind farm development itself. Although it is worth noting that in some cases, this does not preclude the consideration of the overall effect of granting a new planning permission, primarily where the previous permission has lapsed or is incapable of being implemented. Other advantages of making a variation include reduced pre-application consultation requirements and reduced requirements on the content of the application documents. Standard conditions for onshore schemes which are likely to require amendment in these cases include defining the operational lifetime for the wind farm, so for example 25 years from the first export of electricity to the grid, setting a date for the expiry of the planning permission, and requiring the wind turbines and associated infrastructure to be decommissioned and removed from the site within a certain timescale. For planning permission under the Town and Country Planning legislation, so for projects 50 megawatts and under generation capacity, An application to vary a condition of a planning permission is made under Section 42 of the Town and Country Planning Act 1997. A successful application will result in a new standalone planning permission. The equivalent process in England is a Section 73 application. Crucially, the power under Section 42 applies only to conditions, and it does not permit any other part of the permission, such as a description of development, to be amended. Although it's worth flagging that all conditions are open for consideration, not just those that you've asked to be varied. So the local planning authority could, in theory, seek to modernise or extend any of the conditions attached. In summary, it's very important to check the wording of your existing consent. If the project lifespan is in the development description, then an application for a new planning permission is likely required. In addition, a Section 42 application cannot be used to seek a variation that would materially alter the development that was subject of the original planning permission. In the Welsh case of Finney against Welsh ministers, a wind farm operator applied to extend the height of turbines by way of relief from complying with the original conditions of a planning permission. The Court of Appeal found that this was outside the original description of the development and therefore beyond the scope of Section 73, which is the English equivalent, the English and Welsh equivalent rather, of Section 42 in Scotland. Similarly, it may be possible to vary a Section 36 consent by way of a Section 36C application, or to vary the deemed planning conditions in the Section 36 consent by way of a Section 42 application. Changes to turbine dimensions or changes to the operational life are examples of variations that the Scottish ministers may consider appropriate under Section 36C. However, crucially, as with Section 42 procedure, the variation process is not intended as a way of authorising what is likely to be fundamentally or substantially different in terms of scale or nature from what is authorised under the existing consent. I'll turn now to repowering. As we know, full repowering constitutes the decommissioning of existing turbines and installing new turbines in their place. There may be other options that are less substantive, so for example, changes to blades, retaining the turbine components but making blade efficiencies, etc. Proposals for full repowering will, in most cases, involve the full or partial replacement of a constructed wind farm and require extensive construction works. Therefore, generally, a new development consent will be needed, as opposed to just a variation of the existing consent. The nature of this new permission or consent is no different to the planning permission or consent required for the development of a new wind farm. So planning permission from the local planning authority for wind farms of 50 megawatt capacity or less, and consent under Section 36 of the Electricity Act for wind farms over 50 megawatts. If a project that was previously 50 megawatt capacity or under will go over that threshold when repowered, a Section 36 consent will be required. Co-locating a battery energy storage system, which the Scottish ministers consider as a generation station, or other generating technology such as solar panels in your repowered project could also push you over that 50 megawatt threshold. In all cases, pre-application discussions are really important to judge the appropriateness of the consenting strategy in advance of an application being made. Consenting routes should be considered well in advance. For example, developers should consider that if an application to vary a consent is rejected, the alternative is that new consent must then be sought, and this obviously results in delays. It's also important to consider all consenting aspects well in advance of the expiry of existing consents to ensure that you minimise any period of not generating at the site. Lastly, today I want to talk briefly about environmental impact assessment, or EIA, a crucial element when it comes to wind farm planning applications and something potentially applicable to both variations to existing consents and applications for new consents in the context of life extension and repowering. So wind farms with more than 2 turbines are categorised as Schedule 2 development under the EIA Regulations 2017. This means that they will be EIA development if they are likely to have significant effects on the environment due to factors such as their size, nature, or location. In addition, any change to or extension of Schedule 2 development that is already authorised, so for example an existing wind farm, is also Schedule 2 development. And therefore any change will also be EIA development if the change may have significant adverse effects on the environment. Therefore, where applications are being made to extend time-limiting conditions for wind farms, the local planning authority or the energy consents unit, as the case may be, should consider whether the proposed modification could have significant environmental effects. If so, then EIA procedures should be followed, including potentially using the screening procedure to screen a life extension out of EIA, or the scoping procedure to decide which topics will be covered in the EIA. For repowering, it is very likely that EIA will be required, as projects are likely to have significant impacts. But again, the scoping process can be used to ensure the EIA focuses on potentially significant effects only. I will now pass across to Gemma, who will explain a bit more about some of the factors that go into determination of life extension repowering applications.
Thanks, Hazel, for setting out the consenting regime background. I will now be highlighting 3 key factors which you might want to consider when applying for a life extension or repowering of a project. The first being decision making, the second planning agreements, and the last community benefits. Turning to my first point, decision making. When an application for repowering or life extension is being determined, it will be helpful to have a precedent of a wind farm in that location. However, the application will be considered on its own merits. One of the key considerations for determining the merits of an application will be whether there is policy support. The relevant policies for projects will differ depending on the consenting regime. Under the town and country planning regime, the development plan has primacy. The development plan is made up of the National Planning Framework 4, which is the Scottish Government's national spatial strategy for Scotland and is a key document for planning decisions. The other part to the development plan is the Planning Authority's local development plan, which is the local authority's spatial strategy. In the event there is policy conflict between the 2 policies, whichever policy was adopted later prevails. By contrast, if the proposal is a Section 36 or Section 36C application, the development plan does not have primacy. Instead, all relevant considerations should be taken into account, which includes energy policy, the contribution of the development towards targets, environmental impacts, and the development plan. It is, however, worth noting that there is general policy support for such proposals. So Policy 11 of Scotland's National Planning Framework 4 gives general support to all forms of renewable, low carbon and zero emissions technologies, which includes repowering, extending, expanding and extending the life of existing wind farms. The Scottish Government's onshore wind policy statement provides explicit support for repowering, noting the Scottish Government's position remains one of clear support in principle for repowering of existing sites. The onshore wind sector deal for Scotland acknowledges the ambition of 20 gigawatt of installed onshore wind capacity by 2030, which will require the repowering and extension of existing sites. As the number of repowering projects is set to increase, there's been calls from industry for a more consistent approach to categorising repowering decisions. Whilst the onshore wind policy statement recognises these calls from industry, it proposes to continue to determine these types of applications on a case-by-case basis. Therefore, developers must be alive to the various factors which may influence the decision whether to grant a variation or a new consent. In addition to taking into account relevant policies, decision makers must also take into account considerations such as environmental impacts that Hazel outlined. As Hazel also mentioned, there are different regimes that apply depending on the consenting routes. These regimes have different determination processes, decision makers and timescales, which should be taken into account by developers when progressing an application. Turning to my second factor, planning agreements. Planning agreements must be considered when progressing planning applications for life extension and repowering projects. Relevant planning agreements for wind farm projects include Section 75 agreements, road agreements, restoration security agreements and bonds. When pursuing a life extension or repowering, you'll need to review what planning agreements are in place to consider whether they might need varied or a planning authority may actually require an agreement for the first time that they didn't previously at the original consent. If there are agreements in place, consideration should be given on what provisions might need to be varied and do they need modernised. For example, modern bonding provisions tend to require that bonds are reviewed every 5 years, whereas old bonds in Section 75s entered into at the time of the original consent, the bonds lasted for the lifetime of developments. So consideration should be given whether that needs to be modernised. Alternatively, you may need to discharge existing agreements if they no longer work and potentially put new ones in place, or perhaps enter instead of entering into an agreement, things could be dealt with by condition instead. Lastly, moving to my last factor, community benefits. Community benefits are voluntary contributions provided by energy developers to local communities. When pursuing a life extension or repowering application, consideration should be given whether existing community benefit agreements need to be extended or whether an agreement needs to be entered into for the first time. The Scottish Government ran a public consultation on community benefits from net zero energy projects from 19th December 2024 until 11th April 2025, and the responses were subsequently published in October 2025. The Scottish Government earlier this month has published a working paper seeking feedback on proposed updates to the existing community benefit guidance for onshore energy developments. The working paper is called Refreshing the Good Practice Principles for Community Benefits from Onshore Renewable Energy. The paper proposes increasing the recommended annual fund level for onshore wind to £6,000 per megawatt and setting out recommended levels of £700 to £1,000 per megawatt for solar and £150 per megawatt for battery storage. Improved guidance on the governance and distribution of community benefits and the establishment of a community benefit peer forum to provide opportunities for support and knowledge exchange are also amongst the proposals in the working paper. Views on the proposals are being sought until 25th March 2026, so it's definitely worthwhile for developers to review the paper as this guidance will shape community benefit discussions for projects going forward. Thanks for listening, and I'll now hand over to my colleague Tyler to discuss property considerations.
Thanks, Gemma. Earlier in the session, Derek provided a general overview of life extensions, including what they are and how they differ to repowering of projects. In this next section, I will be discussing life extensions in more detail, focusing on key aspects from a property perspective and things for developers to bear in mind when a project is approaching end of life. As Derek summarised earlier, a life extension involves extending the life of an existing renewable energy project, and this is done by extending the terms of the existing project lease or leases and making any associated changes to the commercial terms as a result. From a developer's perspective, recognising the potential need for a life extension as early as possible is a good opportunity to consider the project in the round and think about whether it might be necessary or appropriate to make any other adjustments to the lease documentation at the same time, besides extending the term itself. The starting point, however, for any life extension is to determine if there are extension rights already built into the existing lease documentation. If there aren't, negotiations between the developer and landowner will need to take place, and the outcome of that will ultimately pave the path for how any extension should be structured. Careful analysis of the adequacy of any extension provisions contained in the existing project lease and the future needs of the project can assist in structuring negotiations with landowners. Consideration should also be given for larger projects, as these may involve a patchwork of land rights in relation to the operation of wind turbines and ancillary infrastructure, such as substations, cabling, and access roads. Where multiple landowners are involved, there is an added layer of complexity, and developers should progress discussions as soon as possible to ensure there is sufficient time to finalise negotiations and the necessary documentation. A common method is to vary the existing lease to include an option for the developer tenant to trigger an extension of the lease on agreed commercial terms, and these terms would then be built into the variation itself. This structure is predominantly used for tax purposes because if the extension took effect on completion of the variation, that would be the trigger for LBTT purposes in terms of the extended term of the lease. From what we have seen in our experience, at the point the tenant is looking to contractually agree matters with the landowner, there usually isn't enough certainty that the life extension will actually go ahead. For example, consent may still be required. And so the tenant will not want to incur any tax liability until further down the line when there is more clarity on the likelihood as to the extension of the project. The key takeaway for developers here is that commercial terms will often be at the forefront of a life extension and be the most important thing to consider. The reality is that most original renewable project leases are historic in nature, and this means that key terms such as rent, how rent is calculated, as well as any payments due under the lease and the value of those payments will all likely need to be revisited and considered in more detail to ensure that the varied terms reflect current market approach. Lastly, it is worth mentioning that in certain cases, we have seen developers seeking, as part of the life extension, for the variation to include provisions which give them some sort of exclusivity with the landowner in respect of a subsequent repower of the project. Whilst this is typically structured as an agreement to agree provision, the aim of including that within life extension documentation is to give the developer the first opportunity to progress a repower and seek to agree terms to that effect, which is beneficial from a future planning perspective when considering post-life extension. On the subject of repowering, I will now pass over to Marianne, who will discuss this aspect in some more detail.
Thanks, Tyler. As Derek has already mentioned, repowering, as opposed to a life extension or decommissioning, involves upgrading the infrastructure on a given site to the most up-to-date apparatus and technologies in order to increase an energy development's capacity or efficiency. The structure of the property documents involved will most likely comprise at least an existing development lease and a new development option agreement for the repowering or replacement project. We know already that the repowering market is and will continue to be competitive. There is strong interest not only from operators managing mature projects, but also from developers looking to acquire and revitalise existing assets. For the purposes of this webinar, we are focused on instances where the incumbent developer will be the one carrying out the repowering, though we would emphasise that this isn't always the case. Should you have any questions on this specifically, please do reach out to one of the team after the session. As with life extensions, the first action for any developer is to review and consider the terms of the existing lease to establish what rights they currently have to carry out the repowering, but also what protections they have to guard against competitors looking to enter into a deal with the landowner. Are these stringent enough? And do they cover the maximum extent of the land required? Upon completing this review, we might note that there are certain additional rights and protections needed. The developer will then need to negotiate and agree commercial terms for the repowering. Much of this will depend on site-by-site specifics. We have increasingly seen landowners seeking to explicitly exclude repowering rights and provisions from initial lease agreements in order to force the developer to come back to the table to obtain these rights, which strengthens the landowner's negotiation position when the repowering comes around. If a developer is able to lean on a form of exclusivity with the landowner, or if they benefit from existing protections within the existing documentations, then this will put them in good stead for positive negotiations. Additionally, and hopefully, the operational developer will have a good working relationship with the relevant landowner, which should ideally give an advantage to the incumbent operator over that of a new incoming competitor. As part of these negotiations, careful thought will need to be given to the structure of the new option and how it interacts with the existing lease. In particular, consideration must be given to timing and sequencing. Could the decommissioning of the existing infrastructure take place at the same time as the installation of the new apparatus, or is an overlap in timing not feasible? In some cases, we have seen a form of phased decommissioning proposed. Under this approach, infrastructure would be removed on a staged basis, with the relevant areas released from the existing lease incrementally and then captured by the new option. While this structure may offer a more gradual and commercially manageable transition, its suitability will depend on the specific contractual and operational constraints of the project in question. As Hazel and Derek noted earlier, recent trends suggest that planning consents increasingly will require developers to decommission and remove the existing project in full before any repowering works can begin. This approach can obviously present clear commercial challenges, as developers will naturally want to seek to minimise any period during which the site is not operational and not generating income. It will also be important to consider whether separate special purpose vehicles, or SPVs, should be incorporated to enter into the new option and any subsequent lease, particularly where risk allocation, funding arrangements, or stakeholder requirements differ between the existing and repowered project. This is also assuming that the SPV under the existing lease will have the same parent company as the developer carrying out the repowering work, which, as we've already pointed out, isn't always the case. With all this, I'm sure you'll agree, the drafting of the agreements needed to reflect the preferred arrangements will necessarily be complex, and it is not only the primary lease rights that could add complexity. Areas required for ancillary rights under the new option, for example, areas earmarked for habitat management, tree felling, or compensatory planting, may overlap with the existing lease premises. If these areas are required for the purposes of the new option lease, they may need to be renounced from the existing lease prior to its natural expiry to allow for example, the relevant SPV under the new option to carry out surveys. Next, it will be important to consider access requirements. Given there will most likely be an existing lease covering the infrastructure already in the ground and a new option agreement for the purposes of the repowering, the tenant under the existing lease will likely need to consent to the exercise of the access rights under the new option agreement, assuming that there needs to be an exercise of rights over land that is covered by rights and obligations under the existing lease. If the parties are part of the same group, this shouldn't be contentious. But if there is a new disconnected developer that is undertaking the repowering, this could be less straightforward. The existing developer's consent to the option access right should therefore most likely be formally documented between the parties. Access will then be a further consideration down the line at the point the repower project goes to lease. If the access route has been captured by the existing lease and priority of use is to be given over to the new development, then this area will likely need to be renounced from the existing lease, given it's not competent to lease an area twice. In this instance, and in the event the existing developer still needs to use the access route for decommissioning or reinstatement obligations, they will still require land rights in order to do so, which, in turn, the new developer will need to consent to. This could be achieved by way of a license or temporary sublease, depending on the site-specific requirements. As with our other comments, it's important to note that there will generally be site-specific considerations that need to be borne in mind depending on the structure of the repower, timing, and whether there will or indeed can be any overlap between the decommissioning of the existing project and construction of the repower. In addition, and as with any new project, access out with the main project site needs to be considered in detail, in particular bearing in mind that requirements for the size and scale of infrastructure to be used in a repower will likely be quite different from what was the case with the original project. It's not uncommon to see that during the lifetime of an existing energy development, a number of other developments may be constructed on neighbouring property. Their proximity may mean that they require to use shared accesses or install cabling across the existing development's lease subjects. In these instances, the standard course is to enter into collaboration or facilitation agreements to formalise protections and obligations for both parties. These collaboration agreements are going to be personal between the various developers, and so where repowering is taking place, the new developer and that of the new development will need to be brought into this agreement. In doing so, the obligations, rights, and any payments will need to be reconfigured to ensure these operate effectively with additional parties brought in. Briefly, it is also worth pointing out that from a funding perspective, repowering a site is in practical terms comparable to developing a brand new energy project, only with the additional challenge of dismantling the existing facility. As a result, the same financing considerations and risks that apply to funding a new project, such as installation risk and income stability, will generally arise in a repowering process also. Accordingly, lenders may require a full due diligence exercise or certification process to be undertaken before proceeding. So, to summarise, what are some key real estate considerations for a developer to bear in mind when considering a repowering? Firstly, what does the existing documentation provide for? Is there any form of protection or rights of exclusivity for the developer to repower, or will negotiations effectively have to start from square one? Next, how has the landscape changed? For example, are there any new developments on neighbouring property? Has the landowner's personal views on the matter changed? And what does the economic outlook look like now? Next, what will lenders and funders expect to see? Will an entirely new diligence and financing exercise be required? Or will additional subjects need to be secured? Again, we've covered in today's session specific considerations for incumbent developers, noting that there may be incoming entities who don't benefit from existing rights and protections, which I'm sure you'll appreciate provides its own complexities. As advisors, we are well placed to assess both incumbent and incoming developer entities to answer these questions and assess what is required to achieve these aims. And that now brings us to the end of today's session. But if you'd like to hear more about any of the topics covered today, or if you have specific queries for us, please do reach out to one of the team. We'd be delighted to hear from you. As discussed, our session today has been recorded, and you will receive an email with a link to the recording of this session early next week. Our upcoming sessions are now shown on this slide. Please do use the link provided to check out our next session and book your spot in advance. Thank you very much for joining today's webinar, and we look forward to seeing you at our future sessions.